On the record in the matter of the people of the state of Michigan versus Shayna Horn, 24-02754. Council appearance.
Morning, Your Honor. Case mark hearing on behalf of the people. First, make a motion to practice under Michigan Court Home Operations 120.
Motion granted.
Morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Ms. Horn. Ms. Horn stepped out a few moments ago to get more money to parking meter. She's not gotten back yet. She was here. She has been here. I'd ask the court to consider waiving her appearance, as I believe this is going to be a motion for dismissal. She should be back.
Yes, Your Honor. I haven't seen the victim check in or anything like that on this case. I don't think Ariana duties on the courtroom. I just haven't checked. But at this point, I haven't been able to make contact with Ms. Duke. I haven't seen her. We've attempted several times, so people are unable to proceed.
Your Honor, the defense then would be making a motion for dismissal on this matter.
A motion is granted without prejudice.
Thank you, Your Honor.
No problem. Here's your copy for your client. Just appreciate that. Record in the matter of the people of the state of Michigan versus Anthony Rodriguez, 24-0035. Council appearance.
Good morning, Your Honor. Case mark hearing on behalf of the people.
And good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Rodriguez, who is approaching and will soon be standing to my right.
Anthony Rodriguez.
Yes, Your Honor.
Okay, so today was the date that was scheduled for a preliminary examination, that I see a plea sheet says the defendant's going to plead no contest due to intoxication to an added count 2 of aggravated assault under MCL 750.81A1. That's a misdemeanor, maximum penalty 1 year in jail and or $1,000 in fines. It's complete and accurate as to the plea offer.
Yes, sir.
That is correct, Your Honor.
Do I have an advice of rights?
No, and a one, my apologies. Would you like to somebody to- Sign. Did you were right? This one is let's see. You give them these rights. Okay, sure. You did it? All right. Yes. Your Honor, if I may approach?
Yes. Mr. Martinez, you want to accept the offer that was stated on the record?
Oh, yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, sir.
Have a police report?
Yes, Your Honor.
While they prepare the police report, let me advise you of your rights and make sure you understand them. This is an advice of rights and plea information sheet. Could you read this? You understand the rights listed here?
Yes, sir.
And do you want to give up these rights today?
Yes, sir.
You understand that you have the right to have a jury trial in this matter, and you have the right to the presumption of innocence. So you're innocent until proven guilty, You can require the prosecution prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at any trial and not have silence be used against you, or you can testify at your trial if you like. You also have the right to have witnesses subpoenaed to testify on your behalf and to present evidence that you believe show a defense to the charges being brought against you. You understand each of those rights that you would have to give up today?
Yes, sir.
Is anybody threatening you to get you to give these rights up? Has there any promises made in exchange for you entering a guilty plea? Are you currently on, I'm sorry, a no contest plea, that is? Because you're pleading no contest. Any threats for you to plead no contest?
No.
Are you currently on probation or on parole?
Yes, sir.
Which one?
Probation.
You understand that like pleading guilty could have impact on your probation status?
Yes, sir.
You're on probation at the circuit court
Yes.
until when?
December 25th.
Of this year?
2025.
Oh,
Or
2025.
2024, sorry.
So Christmas?
Yep.
Understand that by pleading no contest, it could result in a conviction that you may need to report to your current employer, or you may need to put this conviction on a future job application.
Yes, sir.
It also could have impact on the travel or immigration status that you may be seeking or that you may seek in the future.
Yes, sir.
And the reason for the no contest plea is because you were intoxicated?
Yes.
You don't remember this incident? Oh. As to the amended count 1 of aggravated assault. How do you plead?
No contest.
Okay, I have a police report here from the Lansing Police Department, case number 235190773. States here on or about August 11th, 2023, at approximately 20:45 hours, officers, that is, Officer Douglas Hall was dispatched to 408 East Michigan Avenue in reference to an assault. Patron named Anthony Rodriguez got kicked out of the bar and shortly after threw a bar sign at a random passerby walking down the street. Officers made contact with the alleged victim, Jennifer Powell. Powell did, however, advise that a male subject randomly hit her in the head with a sign as she was walking down the sidewalk. Powell does not know the male accused. Powell advised she wanted to press charges against the accused for an assault. Officers took a statement from a witness. Witness stated, or advised that she was in the bar looking outside the window when she witnessed the accused, later identified as Anthony Rodriguez, pick up a sign and strike Powell on the head with it. The witness then assisted with first aid until medics arrived. Officers indicated that Rodriguez blew a .374 on a PBT and was transferred to Sparrow Hospital for medical treatment. Or about August 17, 2023, officer or detective, that is Stephanie Kennedy, made contact with the victim. She provided an update that she did go to Sparrow Emergency Room on Jolly on the 14th, where she was diagnosed with a concussion. Any additional factual basis?
Your Honor, people are satisfied with the factual basis.
Nothing further, Your Honor, thank you.
Or to satisfy with the factual basis, I find the reason for the no contest plea to be appropriate. The matter will have an entry of guilty by way of no contest plea. Find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing December 13th, 2024 at 9 o'clock in the morning. Prior to sentencing, you need to probation. So when you leave here, you need to go down one floor, check in with our probation department so they can get you scheduled and set up for a pre-sentence interview. I'm ordering that you undergo a substance abuse assessment. Okay? You have any questions?
So right now, I need to, you said I need to go into the probation.
Yes, on the 5th floor. Correct. Correct. And then you also are gonna have to do a substance abuse assessment prior to your sentencing, okay?
Okay.
And so you'll get more information from that when you check in with probation. They'll get you all scheduled and set up for your pre-sentence interview. Any additional matters for the record?
Nothing further from the people.
Nothing for the third month, thank you.
We'll get you downstairs. On the record in the matter of the people of the state of Michigan versus Brett Salzman, 24-028333.
Your Honor, case mark hearing appearing on behalf of the people.
Put your appearance on the record.
Morning, Honor Attorney Derek H. Phelps, Club Defendant on behalf of Mr. Saltzman. Mr. Saltzman is in the courtroom standing to my right.
Okay, today was the date that was set as or originally scheduled for preliminary examination. I said we would treat today as another probable cause conference. Last week, Mr. Salzman appeared from Ingham County Jail by polycom. He indicated to the court that he had not been in contact with his attorney, and Mr. Etheridge, you were not here. We reached out to your office to get someone to advise you to appear. There was also some indication, I think, from Mr. From APA or Martinez that you were going to log in, but then we subsequently got an email that you had made arrangements for Mr. Mills to appear. Mr. Mills just so happened to have been on the record in this matter on another matter and was completely shocked to hear that. So we did not put him in a private meeting room because he was not prepared to meet with Mr. Salzman. So we would have to address the timeline today if we are continuing to examine.
Your Honor, it's my understanding this can be a referral to special court.
That's correct, Your Honor. I told him Mr. Saltzman, and he will be waiving the timeline where in the matter of sobriety court. I apologize to the court for last week's issues. I did send an email saying that we were leaving it on, and I understood at that time I didn't have to appear. I had made several attempts to contact Mr. Saltzman in Ingham County Jail, and there were some issues where he was in behavior modification. I wasn't able to talk to him, and I did meet with him immediately. I think it was Monday by phone. He has been released from Ingham County Jail. Obviously, he's here today. He's in Pinnacle House and already in intensive outpatient treatment.
Okay, just for the record, my policy is if you've not met with your client for whatever reason, you cannot send an email that you're continuing. You have to meet with your client, otherwise you need to appear.
Thank you, Your Honor. I wasn't aware of that, and I don't think there was an email sent out Friday to make our officer aware of that policy. But I don't think we were completely aware of it.
And so there's going to be a referral to sobriety court. You understand, sir, that you have the right to have your preliminary examination within 21 days of the date that you were arraigned, sir.
Yes, Your Honor.
And due to you being referred to screening for sobriety court treatment, do you want to waive the timeline so that this matter can be reset?
Yes, Your Honor.
Is anybody threatening you to do that?
No, Your Honor.
It's going to be screened for which sobriety court?
Judge Buchanan, sobriety court.
set this out, I think they typically will require some pre-screening, but. Sorry? I don't even know that it requires 30 days because typically Rihanna would have, should have been notified already. Did you all email our probation department about this already?
No, Your Honor, I don't think there's been an email sent about this yet. I didn't know what we were gonna do until today.
Just give me the next available. She would email me back and let me know if he was eligible. We did. Another PCC, yes.
Number 14.
We'll set the new PCC for November 14th at 8:30. Give me an exam date just. in case.
December 19th.
December 19th at 8:30 will be the date set for a exam at this time. Do you have any questions today, sir?
No, Your Honor.
Okay, any additional matters for the record, counsel?
No, Your Honor.
Your Honor, the 11/14 date, I might be in training, CDM training up north. If I am, I'll see if somebody else will be off.
The exam, I mean, the PCC date?
Yes, Your Honor.
Well, if we get an update before then, we don't need to hold the PCC. I just set that for the next available date so that we make sure an email goes out. Our sobriety court screening doesn't take as long as some of the other courts, so
Okay, Your Honor, thank you.
no problem. And then if that's the case, then we can reset it to, if necessary, to another date. Any additional matters for today's record?
Nothing from the people.
Nothing wrong with defense, Your Honor, thank you.
You're all set. On the record, in the matter of the people of the state of Michigan versus Michelle Delaney, 24-01797, counsel affairs.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Morning, Your Honor, Assistant Public Defender Aaron Schroeder on behalf of Ms. Delaney, who I have not seen in the courtroom and I have not seen in the hallway. If I may poke my head out one last time, Your Honor, if I may.
Yes.
Thank you.
No Delaney?
Unfortunately, Your Honor, no, I have reached out to her. I have previously had good contact with her. I do not know why she is not here this morning.
You did provide an updated number.
Oh.
At the last court date, I don't know if you have that.
She and I spoke that day as well.
Oh.
I can-
9072 was the last four.
One moment, Your Honor, let me just get her file pulled up in my system. Oh. (9072)
Yes.
Yes, I've tried to reach out to her there. I left a message for her. I've not heard back.
Okay.
Thank you.
Record in the matter of the people of the state of Michigan versus Carl Knox, 24-02343. Got you moving today, Ms. Schroeder.
It really is. Your Honor.
Counsel here.
Morning, Your Honor. Case Markarian appearing on behalf.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder, appearing on behalf of Mr. Knox, who is present and appears today to my right.
Okay, Mr. Knox, today was the date scheduled for sentencing. I do have a pre-sentence report. It was prepared back on October 11th. Counsel, did you get a copy of that?
Yes, Your Honor, and I have reviewed it with Mr. Knox, and I also have sent in a copy of it as well.
Corrections, updates, or deletion?
No, Your Honor.
Okay, at the time of your sentencing, I told you you needed to have a substance abuse assessment and that you would need to meet with our probation department. Why did you wait until 8 days before sentencing to do that?
Undergoing chemotherapy, so I was at the hospital. Back.
She's in the hospital, you said?
Yeah.
Okay. Do you think that you could really be supportive of her if you're sitting in jail? What do you think's gonna happen if you don't follow the court orders?
Yeah, at the time when your mom going through that, you really don't just be racing, but you don't think about besides her health.
I have a mother, I understand, but I also know I understand responsibility. And not to negate that you don't need to be there for your mother, but you have to still take care of what you're supposed to take care of so that you're not sitting in jail for violating a court order, then you're not there with her at all. You understand that? So now I'm at a situation where I don't have a substance abuse assessment on a case where substance abuse is the issue, or substance use is the issue. How do I know how to sentence you? Typically, when you don't follow court orders while you're in between disposition of the case and sentencing, it's a signal to the court that you're not going to follow the court orders if you're on a probationary period.
I went down there and talked to him, take time. It was cool.
You have an appointment?
I already seen him.
No, you've seen who?
I saw my probation officer.
You saw the probation officer for a pre-sentence interview, but you were supposed to see him within 48 hours of your release from custody. Not 8 days before your sentencing. And so his report clearly states we don't have sufficient information because you weren't able to complete the substance abuse assessment. Are you employed, sir?
Yes.
Where?
Home health care.
Is your mom home or is she in the hospital? Oh. And so that's your only employment at this time?
Yeah, I work odd jobs with my uncle too, cleaning up sports bars before they open.
Are you still on probation?
Yeah, I got 1 month left.
You have something pending in Jackson? Jackson County? Why were you were transferred to Jackson County after you
Oh,
left?
yeah, it was child support.
Oh, okay. Council, you can make allocation.
Thank you, Your Honor. As the court has pointed out, there has been some timing issues, hope to mildly for Mr. Knox, however. I think he's had a lot going on, and it's not to say the court is not important. It absolutely is the most important thing for him right now. Obviously his mother, but in order to be out for his mother, he has to be able to have the court allow that to happen right now. I think he is abundantly aware of that. I think he was in a panic mode though, as he had been, and he spent almost the entirety of the month of August in custody. And then he had to be transferred to Jackson County after he was released on a PR bond from this court on the 29th of August. So getting back from Jackson County and then getting things back together for his mother and then getting into probation and having to go in for her to go, like a go inpatient, I guess that's what to put it, at the hospital for chemo after being home and being cared for. I believe at this point, though, he is more than capable and very much willing to get himself wherever the court needs him to be in terms of programming, and a very much a willingness to do it. I think though, at the time, the last few months here, I think there's just been he's had a plethora of things going on that unfortunately he made some choices to what to prioritize. And at this point, I'm hoping things have settled down enough that he will be able to, and it sounds like he has a probation officer who's recommending to give him at least the opportunity to get things moving in the right direction. He did show up with PSI. I realize it was late in the game, but he did show up. He got it taken care of. And it is prepared in time today. I would ask the court to allow him the opportunity to get that assessment completed and follow the recommendation that is provided by Agent Hannah at this time. Thank you.
Yeah, the unfortunate issue is I don't know how to individually tailor a term of probation for him because he didn't follow the court order. And I'm not at all minimizing your concern over your mother. I understand if your mother's health is at stake, that could be troubling and that could be time consuming. However, you also have responsibilities that you have to take care of. Like I said, I obviously have a mother. My mother's elderly. I have sat in ICU and handled court because my mother was in ICU. I didn't blow off my responsibility because of what was going on. I took care of it. You understand that? You have a responsibility, you gotta take care of it. If you don't, then I have no choice but to put you in jail, and then you won't be there to support and be with your mother during this time. That's not the court's first choice for you, but if you don't follow what you're supposed to do, I don't have a choice. The recommendation was to put you on a term of 6-month probation and then have you be screened. I'm gonna put you on a term for 9 months because you haven't been screened. And so I need enough time for you to be screened and for me to see what programming you need, because it may take at least 30 days to get you scheduled for screening. These are the reasons why we schedule your sentencing so far out from the time that you took the plea. So we'll adjust the timeframes if necessary, but we'll start you off right now with 9 months. You're going to be required to do a screening for substance abuse assessment. And then you'll complete any outpatient or inpatient treatment as recommended, okay? Not to purchase or possess firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol or drugs or marijuana unless you have a valid prescription, okay? You will be required to submit to random preliminary breath testing and your analysis testing. You have to pay the fee for that. You're not to be in any bars or any nightclubs. Will be required to obtain and maintain employment and provide verification of that. Ordering 365 days in county jail with credit for 22. Will suspend the balance upon successful completion of probation. There's an advice of rights as to probation. You have the right to request early discharge from probation once you've completed half the original term ordered by the court, so long as you completed all the programming that I've ordered you to do and you've not had any violations within the 3 months preceding your request, okay? You would use the court's NC 512 form. That's the form For eligibility for early discharge from probation, you would get that from your probation officer, or you can get it offline. And once you complete that form, you would file a copy of that form with the probation office, but you must file a copy also on the prosecutor's office. They have 14 days from receipt of your request for early discharge to object in writing, okay? If I set a court hearing, which is unlikely, but it could happen, you have the right to have an attorney represent you at that hearing, but you would have to hire the attorney. You do not have the right to court-appointed counsel for any hearing for early discharge, okay? Your attorney can also, your probation officer, that is, can also make the request for early discharge on your own if you're doing fine and there's no issues, okay? Do you have any questions? We need that one back. No problem. You know, I'll put that back in. Still checking with probation on your way out so that you can get the information about how you go about completing your substance abuse assessment, and then you'll be on your way. Any additional matters for the record?
Nothing further from the people.
Nothing further from the defense.
Good luck to you and good luck to your mom. sir. Dominic Boca here?
Yes.
Okay, on the record, in the matter of the people of the state of Michigan versus Dominic Roca, 24-01787, Councilman Terrence.
Morning, Your Honor. Case Mark Hearing, appearing on behalf of the people.
Here, Robin, this is the public defender for Mr. Roca.
Okay, today was the dates up for sentencing. Mr. Roca. We have a PSI here, was prepared back on the 15th. Did you get a copy, Council?
I have.
To make corrections, updates, or deletions.
No, Your Honor.
Make application.
Yes, Your Honor, we'd ask the court to follow the recommendation put forward in PSI. Sentence Mr. Roca to a term of probation. He is willing to complete the treatment that has been requested and likely be required of him placed on probation. He admits that he made a lapse in judgment that day and is willing to complete the programming. So we'd ask the court to follow the recommendation.
Did you quite want to make a statement about?
No, he does not.
Okay, I reviewed the sentence report as well as history. I think in terms of sentencing is appropriate, as well as some outpatient treatment. The defendant was or did meet the criteria for a mild alcohol use disorder and a mild stimulant use disorder. 9 months probation will be ordered while on probation. Will participate in outpatient substance abuse treatment. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol, marijuana, or controlled substance. And you are required to submit to random preliminary breath testing in your analysis testing, and you have to pay the fee for that, okay? Did you see that fall down? Did I hear that last guy's phone back? I just forgot. You're not to be in any. The guy that I just gave you. You're not to be at any bars or any nightclubs while on probation, and you need to maintain employment. I see that it says you're employed at Clean Team USA right now.
Right.
You'll provide verification of proof of employment to probation. Do you have any questions so far? It's a $30 per month oversight fee that you will be responsible for each month of probation. So that's $270, $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost that will be assessed. I'm gonna waive discretionary fines and costs. Total fines and costs are $395. And you'll be able to make monthly payments on that, okay? That's a device of rights as to early discharge for probation. It explains the rights that you have to request early discharge for probation. You must complete half the original term ordered by the court. There cannot have been any violations within the 90 days preceding your request, and you must have completed all of the programming that was ordered as well. You can make your request by using the court's MC 512 form. You can get that off the court website, or you can request it from your probation officer, file a copy of that with probation, and then serve a copy on the prosecutor's office. They have 14 days to respond in writing with any objections to your early discharge, okay? If I set it for a hearing, you can hire an attorney to represent you for that hearing, but you don't have the right to court-appointed counsel for that hearing. Do you have any questions about that?
Oh, man.
Okay. I'll get you downstairs to check in with probation in just a moment, and then you'll be on your way. Any additional matters for the record?
Nothing further from,
No, Your Honor, thank you.
You're all set. Okay, my understanding is that we're running Zachary Layton.
I think it's gonna be an adjournment request now, actually, Your Honor.
On the record in the matter of the people of the state of Michigan versus Zachary Layton, 24-02961. Appearance, please.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Stephen Milton, behalf of Mr. Layton. Mr. Layton is present and standing to my right.
Okay, today's the date that was scheduled for preliminary examination. I think this was the matter we were potentially going to get a motion to the constitutionality of the stop. How are we proceeding?
Thank you, Your Honor. Your Honor, at this time, I am requesting, the defense is requesting an adjournment. We would like additional time for me and my client to sit down, meet, go over the evidence in greater detail, and to review body cam footage as well, Your Honor. I don't
How
believe
much
that-
time do you need? Well, I guess that's really our next available data so far. I don't think it matters at this point. Okay. You understand, sir, that you have the right to have a preliminary examination within 21 days of the date that you're arraigned? Okay, and due to the evidentiary issues, some additional discovery that's going to be reviewed by you and your attorney, do you want to waive the timeline so this could be reset? Okay, anybody threatening you to do that?
December 19th at 9.
December 19th at 9 a.m. Have any questions for the court today? Okay, any additional matters, counsel?
Nothing further from the people. Thank you.
Nothing further from the defense. Thank you, Your Honor.
Time will continue, you're all set. Okay, you're not in custody.
She,
Alyssa did.
she was on Zoom too, and then I think we had her respond to tell her that she.
I'm going. Okay, sounds good. I've not seen Miss Donnelly. Are we supposed to do something with McDermott?
I'm trying to figure out the issues that I have with McDermott now, Your Honor. I subpoenaed multiple officers with the intent to run the unlawful imprisonment case victimless. I know there are no case as well. I subpoenaed the officers on that. Officer Pulver just advised me that apparently he didn't get a subpoena, even though I show that he has one sent to him, but he's on his way up north for a training. So he's unavailable. And if I could step out for a moment, I might be able to get the other officers that I was planning to run victimless with them down here, or at least see where they're at, but I sent them an email and they haven't responded.
Your Honor,
Yes.
I represent Mr. McDermott on the unlawful imprisonment case. I will be filling in for Ms. Donnelly on the R&O case. She
Okay.
is currently in trial.
Sounds good. Okay. Let's see, we'll give them opportunity to see what's going on with that. I was just gonna ask about Alyssa Stead, but she's logging into my Zoom room and that's not good for her. That's what I hear, but apparently. Instead,
Yeah, hello. Yes, hello. Sorry. I don't know what's been going on my phone.
I don't know what's going on your phone either, and I really don't care because I shouldn't see you by a phone. You're supposed to be here in person.
And I didn't get informed of that. I'm sorry. I didn't get a paper for that. I didn't know. I was unaware of
Is
that.
Oh, okay, well, then you'll get a benchmark because you got a paper for it.
I did not get a paper for it.
Yeah, you did.
I truly did not.
Yeah, you
It was
truly
told to
did.
me that my
I have
two.
a copy of it. I have a copy of it in the file. We don't do a single preliminary examination in this court over Zoom. Every single preliminary examination is in person.
Okay, my personal defender, my public defender did not even tell me that. I swear she didn't. I did not. I was not aware of this.
The paperwork we gave you did tell you that, and lucky you, I arranged you. I always say it.
I got the blue paper that said that those were the Zoom, that it was
That's for your
acceptable
probable
for.
cause conference. I say you can appear by probable cause conference via Zoom. Your preliminary examination is in person. You need to get here or you're getting a bench warrant with a remand, meaning you will not be getting a bond until I decide that you get a bond.
So how long do I have to get there?
You were supposed to be here at 9 a.m. You're already an hour late.
I understand that. So how long do I have to get there?
This is not the first time you were told today that you were supposed to be here.
Yeah, and she
Someone
told me
else-
she was gonna contact me and tell me if whether the Zoom was okay or not.
No, my court staff told you to be here.
She told me she was gonna call me back and tell me.
I don't, ma'am, you get here in the next 20 minutes or I'm issuing a bench warrant.
Okay, great.
Good timing.
Ms. Stid, it says she was waiting for you to call her back to tell her if she could appear via Zoom. I told her she should be here in 20 minutes or else I'm issuing a bench warrant with the remand.
She wanted me to ask if she could appear by.
I can imagine. No worries. We don't do preliminary examinations via Zoom.
We just got give her more time. She lives in.
I told her I'd give her 20 minutes. My record says she lives in Mason. I arranged her. She gave me an address in Mason. Okay, let's see. Mr. Milks is back. Monique Williams,
Yes, we're ready to go, Your Honor.
what are we doing?
Your Honor. Well, you want us to make our appearances first, Judge?
I just want to know if we're running or not.
No, Your Honor,
Oh.
she's not, she's currently in Eaton County Jail, and if she's not there, she's been extradited to Texas.
On the record, in the matter of the people of the state of Michigan versus Monique Monet Williams, 24-01317, council appearance.
Morning, Your Honor. Case marked hearing and appearing on behalf of the people.
Good morning, again, Your Honor. Stephen Milks on behalf of Ms. Williams. Ms. Williams is not currently present.
Okay, today was the date that was scheduled or rescheduled for an exam, and you said she's been extradited?
Let me, that is my understanding, Your Honor, that in Eaton County, she was picked up. There was an extradition case going on. It's my understanding, I got information from Ms. White, right out there in Eaton County. I just want to make sure I bring this up. Where she indicated that, yeah, there is an extradition hearing that was going on, case number Eaton County 24-1124EX, where the afternoon of my correspondence that was on October 8th, is that there was an understanding that she was going to waive, an extradition would occur. And so it's my one that she was in Eaton County. I don't think she was writ over. I'm not certain if the court was aware, but then there's also a chance, very likely chance that she's been extradited to Texas at this point.
Filing test transfer. Filing does indicate she was transferred, so.
Your Honor, may I?
You may.
I did receive a voicemail from what sounded like Monique Williams's stepfather a couple weeks ago. I don't talk to defendant's family, so I didn't respond, but he did say the similar things about she's going to get extradited to Texas. Regarding the victim on this case, Ulysses Allen, and I know this is a case that has been adjourned a lot. To be clear, last time I was here, I said that if the victim did not contact me, if we did not speak, then I was going to move to dismiss. We have emailed, but I still have not been able to make phone contact with him, and I do not see Ulysses Allen here today. I'm fine with the dismissal on this, Your Honor, given the extradition. I would just ask that it be done without prejudice.
That would only. We'll still have count 3, which is Jessica Banks. Did you dismiss that already?
I haven't heard from Jessica Banks either, Your
Oh,
Honor.
okay. Counsel.
Your Honor, if that is the people's desire, we would request dismissal at this time. I believe it's appropriate. Obviously, they can reissue if and when she comes back to Michigan. I'm not certain what the charges are, what the deal is out in Texas, Your Honor, so I cannot speak.
Dismissal without prejudice is granted. Any additional matters for the record?
Nothing further from you.
Nothing from the defense. Thank you, Your Honor.
We'll get you a copy in just a moment.
Your Honor, Mr. Mills' other matter, Ray Quan Punches, is also going to be a dismissal. I just want to get the record on that.
Did you want to have it brought up, Mr. Mills?
I don't need him brought up, Your Honor. Just gonna result in dismissal.
On the record in the matter of the people of the state of Michigan versus Ray Quan Punches 24-02999. Counsel appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Funches. Mr. Funches is currently in holding, and we waived his appearance for purposes of today's hearing.
Today was the date that was scheduled for preliminary examination, and the prosecution wanted to make their record.
Yes, Your Honor. We did make contact with necessary witness on this case, the victim Anastasia Lara. She indicated to us she was not interested in prosecuting this case. She did not want to continue with this case. She was not planning to appear, and I have not seen her today either. Therefore, the people are moving to dismiss.
Without objection, Your Honor.
Motion to dismiss without prejudice is granted. Okay, you need to check on McDermott, correct?
Yes, Your Honor. I believe Mr. Martinez is going to step in on the Bush matter, so that should give me
Okay.
enough time.
That's an adjournment request.
On the Bush matter, yes, it is, Your Honor.
On the record in the matter of the people of the state of Michigan versus Ernest Bush 24-03003. Did you want to brought up, counsel?
Not if the courts can grant their request.
I don't know then.
There was an email that went back and forth to Mr. Pfeiffer and myself, and Your Honor, I think I copied it by Mr.
Oh, I
Pfeiffer.
think I did see that, okay.
It wasn't in the emails, Your Honor. I apologies for not being here personally.
This was the matter that had, another case.
Yes.
I remember Mr. Pfeiffer stating he wasn't on the other one, that he wasn't gonna be here. Was he at trial or something?
He is in trial currently in the circuit court, Judge. He's finishing up a circuit trial today. So that's why he's not here today on this. I believe he will be available. Don't quote me on this, but I believe he will be available next week for the probable cause conference on the other
On
file.
the other one, okay,
Yes.
sounds good. And so we have, it's this issue of the same victim,
Yes.
and my recollection of the email exchange was he wants to run them in tandem, correct?
Your Honor, that is correct. And in addition to that, I also have an officer, Officer Uberak, Bailey Uberak, who's the main officer on today's case, who's unavailable today. So I wouldn't be able to proceed without the officer.
Is he at drone training?
I believe so. That's what he.
It's been all week,
Yes.
it's drone training stuff.
To be fair, Judge, my understanding simply was from Mr. Pfeiffer saying that he didn't want to inconvenience the complaining witness. Didn't mention to me he was in trial, didn't tell me anything about the drone training. I learned that from the very distinguished Mr. Martinez this morning, who informed me of these things. Would have changed the tone, at least the inflection of my email. Also, if he just called me first, would have changed.
He's
my
in
email.
trial, he's busy.
I take phone calls after hours, and
Do you?
I do. He knows myself.
Oh, okay.
And so he copied the court on it rather than asking me as professional courtesy, so I object. And now that I have been compounded upon these exact standing courts decision.
Just to be clear, yeah, if it's two cases with the same victim, I don't know what the nature of the issues are here, but I see the bond amount. I likely would have granted it just for the issue of judicial economy anyways. Nonetheless, he's not here. He's probably the best person suited to do this versus having someone else handle it or step in on his behalf. And now we have the drone training running into today too. We had this issue yesterday with the drone training. So I'll find good cause based on those reasons to go beyond 21 days and reset this. He's scheduled for Mr. Bush has a PCC next week,
Correct.
and then there's an exam the week after.
That's my understanding. Judge.
That date's fine though,
I did not object to.
because I'll just reset this
regular
to that
dates.
date. Yeah.
Did
I'll
I-
just
Yeah, I think
reset
we can
this
just
one
be
to
fine
that
for the
date.
first,
Okay.
Judge, which is November 1st, I think is the prelim. I've already met with my client multiple times, already received the discovery on both files and gone over with him to provide 2 copies, and he would like them left on for exam. So I had simply sent the court an email letting the court know that, so that we could keep both things set. If we're gonna be on one date, that's fine.
Okay, sounds good. So
I-
since that date works, we will set this for a exam on that date.
I will update Mr. Bush, Judge.
Very good. Any additional matters for today's record?
Nothing additional from the people. I appreciate the court's indulgence on that. Thank you. No, Your Honor, thank you.
Thank you. Dr. Bush. Just checking on adjournments. And then that just leaves Mr. Goodrich with Garcia. Did I miss somebody? Oh, instead didn't get here. Yeah,
She's doing 90 on the highway right now.
I'm sure. be seated.
I just need the prosecutor.
That makes sense.
On the record, in the matter of the people of the state of Michigan versus Levant McDermott, 24-02934 and 24-01757. Counselor Sharon.
Good morning, Your Honor. Case Mark Darian appearing on behalf of the people.
And thank you, Your Honor. Jared Austin appearing on behalf of Mr. McDermott, who is not present in the courtroom, but he's present.
Okay, are we proceeding on this today?
Your Honor, I have a request for an adjournment on both of these matters due to witness unavailability regarding the unlawful imprisonment domestic violence case. My intent was to run that victim list, even if I don't see the named victim more fit on that case. Officer Tyrese McClinton and Officer Colleen Riley were both subpoenaed for this case. Officer McClinton did the initial response and report. However, Officer Riley is the one who actually took the victim's statement, and I would need to run the exam victim list pursuant to 27C. I just spoke with her off the phone. One of my detectives called her. She advised she just had surgery yesterday, so she is unavailable, and she did put off requests for this, and either they didn't make their way to me or I dismissed them. So she is unavailable for that. I would be requesting an adjournment for that reason. Regarding the resisting and obstructing case, Officer Damon Pulver is the one who is listed as the named complainant on that case. Officer Pulver did email me back this morning when I asked where he was. He advised he did not get a subpoena, although my records show he was sent one. Regardless, he is headed up north for the training that I believe a lot of officers are in, or that is coming up soon for a lot of officers. So he's headed up north for training right now. So he is also unavailable. I have not seen Officer Nicholas from phone on that. He was just back up anyways, but he was subpoenaed.
Okay.
And I think it would probably make the most sense to just reset the PA 53 as well, if Your Honor is willing to request the adjournment or grant the adjournment request.
You said the PA 53.
Yes, Your Honor, there was I don't know if it actually made it to the docket yet, but there was a report submitted to the court this week, I think Wednesday this week.
I haven't got it yet.
So that might be another reason to reset it, Your Honor, just to have all these things run at the same time. There was a report, I think even Addie maybe sent it over to both of us.
Nothing in the file.
Is it misdemeanor case or felony? Is it attached?
Maybe it hasn't made its way to the court yet.
You said my staff sent it to you?
Maybe it hasn't made its way to the court yet. I know Detective Kennedy submitted it to the court and I turned it over to Mr. Austin. Maybe it just hasn't made its way to the court yet. My understanding was Detective Kennedy was submitting it before.
You don't need anything from me. We've not received it at all.
I'll double check with the detective.
As to the assault, timeline has been waived already, but not on the imprisonment, so.
It was this, the one with the jail calls. Is that,
Oh,
Yeah, it's a
allegations of jail calls.
Yep.
Okay,
we just have to receive the report.
okay, let me have to McDermott brought up. The record on that one. On the record in the matter of the people of the state of Michigan versus Gino Garcia, 24-00948. Council appearance.
Morning, Your Honor. Case Mark Varian appearing on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Garcia, who is standing to my right.
Okay, Mr. Garcia, today's the date of the schedule. And it's for examination on controlled substance possession. How are we proceeding?
Your Honor, I believe this one is going to be a joint adjournment request. I'll let Mr. Goodrich speak for himself on that. Regarding my request for an adjournment, we've tried to get in touch with Detective Stacy Speck, who is a part of the Tri-County Metro surveillance on this. Detective Speck is unavailable to be contacted. I'm not sure why, but we've had people try to contact her several times. So I would be requesting a continuance if we did start it today anyways. However, there was an issue with the body worn cameras on this and how they were uploaded. I just confirmed with the officers. They are uploaded. They do exist. They were just tagged under the wrong ID. So we have not, myself and Mr. Goodrich both have not even seen the body cams on this.
Your Honor, that is correct. We would certainly like to see an adjournment as well, as opposed to starting and stopping the exam. And plus, we would like the video specifically prior to the testimony of Officer Armstrong.
We said it.
December 19th and 9:30.
December 19th at 9:30. Any questions for the court, sir? Any additional matters for the record, counsel?
Nothing from the people.
Nothing from the defense, Your Honor.
You're all set. Here on the record in the matters of the people of the state of Michigan versus Lamont McDermott. Council, can I have your appearances again?
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. McDermott in file 242934 FY. Also appearing on his behalf in file 241757 FY on behalf of this counsel of record, Ms. Donnelly. Mr. McDermott stands present with me at council table.
Okay, and Mr. McDermott, we brought you up because the court's been made aware of some scheduling concerns on, it appears, both of the files that were scheduled for today, and file number 24-01757, which is the police officer assault. There was an officer subpoena, however, looked like he did not, for some reason, receive his subpoena, but was also heading to a training out of state anyway, out of this town anyways. So the court is going to adjourn that matter due to the scheduling conflict. In 24-02934, there's a false imprisonment in a domestic violence second offense. That matter, we also have some issues with officer scheduling. One officer who's essential, just having had surgery yesterday. And the other concern is that there is a pending PA 53 bond violation that is making its way to the court on this matter for some allegations of jail costs. And so because of that, I needed to have you brought up because the timeline on this has not been addressed. And I want to make sure you're clear that you have pending bond violation that's coming through the pipeline. So I need to go over your bond conditions and explain that to you further. In addition to that, you had the right to have a preliminary examination in this file within 21 days of the date that you were arraigned, which was on September 27th. But due to the issues of this officer having surgery and bond violations that are making its way to the court, I'm going to find good cause to go beyond that timeline and reset this matter, okay? Let's see. You can.
If I was just to go ahead and admit about the bond violation, then you go ahead and get that.
It was gonna be reset regardless, because the officer is not here. She had surgery yesterday.
On the bond violation.
The bond violation is just gonna be reset anyways, because we haven't gotten it. They haven't even arranged you, so I can't even have you plead. I'm not arranged you on the bond violation. I have not seen the complaint yet. And then the exam has got to be reset regardless because the officer is not here.
Okay. 7/20.
You said when?
20.
Coming down to the end of the year on this one here, because that's my last thing for the year.
Okay.
I'm off for a state. What now you said? 8:30. This is gonna be reset to December 20th at 8:30. Well, both of them will be set to December 20th, 8:30 in the morning. Let's see. We first address bond petitions because you have a 70. Let me see, I remanded you on 24-01757, and that's because you had a 7,500 cash surety bond. You had an offer, looks like disorderly jostling. I amended your bond to a personal recognizance. You failed to appear in June. You failed to appear in August. And so I had to remand you. I think we didn't see you back here until September. That brings us here to October. 24-02934 case, your bond was 15,000, 10%. So you've not posted bond and you're otherwise being held on the other matter. And because you were remanded on that one. And bond conditions were put in place. There was a no contact order. that you were not to have contact directly or indirectly with the alleged victim in this matter, Lauren Ritt. And allegations are now being made that you have made contact from jail. Just so you're clear, when there's a no contact order, that doesn't just mean when you're outside of the jail, definitely means when you're in the jail. And so I want to advise you that you're not to have contact directly or indirectly with Lauren Ritt. That means you can't make any jail calls or have any video visits from the alleged victim. You can't have another inmate contact her on your behalf. You can't have another family member call for you. Jail calls are recorded. Did you know that? It does advise you of that, correct? Okay. I don't know why people in jail listen to that recording and just blatantly disregard it. I don't know why they would do it.
I didn't know that.
Oh,
I did, it wasn't.
I don't know. Did you get a copy of your release for the PA? It says the pretrial release order. Did you get a copy of it?
I got this paperwork that I had.
Okay, the pretrial release order, it says that you're not to have contact directly or indirectly with Lauren Ritt. It doesn't say that that doesn't apply during the time that you're in custody. Actually, to the contrary, it's a note there. It says this condition also applies while the defendant is in custody.
I didn't read that.
No, it's on the bond, the pretrial release order. And so when you were arraigned, the magistrate who arraigned you would have advised you of your conditions.
Yeah,
All these.
I was read that in court when I was in front of that.
So why do you think, just humor me, why do you think that we would advise you that you can't have contact with the victim, but it would only apply when you're outside?
Because as I understood it, it was part of my release. The bond condition was, like, I thought it meant that once I posted bond, that's when the condition started.
Do you understand the purpose of the no contact order?
now.
What is the purpose?
Purpose, just to not persuade the witness as far as the case
It's
involved.
one of the purposes. It's also for the protection of the victim.
That victim, that's what I mean.
Correct. You understand that?
Yes, ma'am.
Okay, and so if there's a no contact order, you can't contact.
Correct.
Doesn't mean that you can contact them while you're in jail and then when you get out.
Yeah, that's what my misunderstanding of that
Right.
bond order was. And I admitted my fault.
Okay.
No excuse on it.
Okay, so nonetheless, I'm reminding you that you can't have any contact, whether you're in custody or out of custody. And that you cannot have anybody else contact on your behalf. You understand that? Any questions about your bond condition? Any additional matters that we need to address today?
Nothing from the people.
Just a couple brief matters, if I may, Your Honor.
Yes.
I understand the court's finding of good cause, and I'm not going to argue with the court. I just wanted to preserve an objection to that on Mr. McDermott's behalf to the adjournment request. And also, Your Honor, on an unrelated matter, Mr. McDermott has a pending misdemeanor file with this court as well. The notes reflect, I think he was set for a pretrial conference the other day, but I think because of the court's pending misdemeanor trial that was not held, it does not appear that there has been a new date set for that. So I was just wondering if we could get a new pretrial conference date on that misdemeanor file, Your Honor.
Let's see. Assault battery. Which she's probably just gonna request for final pretrial anyways. Let's see. What's the next available date? For pretrial. Pretrial.
You do November 5th at 10:30.
November 5th at 10:30. On that file. And any additional matters?
From the people.
I have nothing additional on behalf of Mr. McDermott, Your Honor. Thank you.
Thank you. You're all set.
Thank you, Judge.
You're welcome. like.
I did just see Mrs. Stood walk in, Your Honor.
Can I get Ms. Wong to take her?
She did, she just went to go. speak to him.
Is that all right? The record in the matter of the people of the state of Michigan versus Alyssa Stidd in 24-02549. Appearance, please.
Good morning, Your Honor. Case number carrying appearing on behalf of the people.
Today's date that's scheduled for a preliminary examination. Are we running this today?
Having a waiver.
Your Honor, we would waive this exam. The people would waive their exam unconditionally as well.
That's what you want to do, ma'am?
Yes.
Okay, you understand that you have the right to have a preliminary examination here in the district court?
Yes,
You
sorry.
understand the purpose of the exam?
Yes.
You have the right to have the prosecution put forth evidence at the district court level to establish that they have sufficient probable cause
Yes.
to charge you with the crime and probable cause sufficient that the crime was even committed. You understand that?
Yes.
And you wish to unconditionally waive your right to an exam today?
Yes.
Anybody threatening you to get you to waive your exam?
No.
Any promises being made?
No.
Okay, I see there was an offer that was extended. Is that offer going to carry over to circuit court?
I have no issue with that, Your Honor. I wasn't told to just leave it in district. That offer can stay open.
Okay.
Yeah.
Thank you. Are you waiver to be freely involuntarily given? Your bind over date's gonna be October 30th. That's the date the circuit court's gonna get the file from the district court, not the date that you need to appear in court, okay?
Can you repeat that last part?
Yes, your case will be bound over to the circuit court on October 30th. So that means that they're going to get the file from this court on the 30th. You do not have to appear in circuit court on the 30th, okay? Your next court date is going to be a pre-trial, okay? Are you okay, ma'am?
Yeah.
Okay, okay, it's gonna be a pre-trial and your attorney will be made aware of that date. What is your address?
1685 Stillman Road, Mason,
And your phone number?
517-275-1457.
Give us the last four again.
1457.
It's your responsibility to update the court if your number changes or if your address changes, okay?
Okay.
Okay, let's see, bond was set at 2,500 personal recognizance that will continue. Any additional matters for the record?
I think for the people, thank you.
Not before the defense, thank you.
You're all set.
Thank you.